Hi, everyone, and welcome to the ESCA Legal Lounge. Super excited today. We have all of our partners here to talk about trending topics in IP. We're going to talk about the massive size and scope of knockoffs and counterfeits in today's digital age. We're going to talk about some trending topics in licensing and contract negotiation, and also AI issues involving patents and copyrights. So thanks everyone for joining us live today. How is everyone here? Leo, Nicole, Angela, how are you guys?
Good.
Good.
Happy Monday.
Good. Yeah.
Happy Monday. Happy Halloween Monday. I'm sure everyone is
Yes.
either recovering from the weekend or you're getting ready to do all kid stuff this week.
I'm the
And
latter
all
camp.
the trick-or-treaters.
Yeah. Are you guys dressing up?
Yes. We do a full on family thing. We lean in every year.
Or what are you being?
We're the family from Bluey because we have two girls. So my husband and I are the mom and dad, and then we have our two girls, and we're basically just wearing full snuggies, which is so comfortable. But then I heard it's going to be like 76 degrees, so I'm going to be
Yeah,
sweating, running after my children. But I'm excited.
that's great.
Yeah.
Angela, what are you doing?
I don't know if I'm dressing up this year. Some years I do, but my kids are. But they have a collection of costumes that they play with a lot, and they each pick their own costume. So we'll see if they actually stick with it. Because last year, each event they went to, they decided to change their costumes. So,
Of course.
but it's kind of fun anyway, right? You get pictures of them in different costumes, and they use them all. But I'm pretty psyched that it's actually a little bit like fall today, though. I feel like it's hot
Yes, it's cold.
and actually fall.
Leo, are you going to get to do anything fun?
Sorry about that. Doorbell
Oh, you're
randomly
good.
rang. Yeah, had a good weekend. Gonna have a little scary movie marathon on Thursday and welcome the trick-or-treaters.
That's fun. It must be fun trick-or-treating in the city. Like, you just get to go in your whole building.
I would imagine, yeah. And there's a lot more kids in Crown Heights where I am now, so it's I'm sure we'll get to see a lot of trick-or-treaters.
Are you dressing up?
I dressing up? That's a great question. Haven't
Paul
decided.
is going to make you dress up.
Yeah, I have not decided yet. I very well might, but I'll let you know.
Okay, we need to see photos if you dress up.
We should have done this legal lounge in costumes.
Yeah, right.
This is my costume.
Yeah, this is my costume too. Overtry
Exhausted lawyer. Yeah, no, I'm really glad we're doing these because as you guys have seen, we do this video live, but then we've been able to clip up some of the tidbits from everyone. So maybe we'll just all go around, and the topic that we picked today is trending topics that we're each seeing in our own particular practice. A big theme of our firm is the modernization of law and also uh, keeping our finger on the pulse to help get ahead of some of the legal issues that brands are facing in the ever evolving, fast digital landscape, whether it's TikTok Shop or new social media platforms that are popping up. Brands have to be aware of where infringing products are being sold and how to protect their IP in these marketplaces. So all sorts of crazy stuff we're seeing. So we wanted to give you real concrete, like boots on the ground info on what we're doing, what we're seeing, and kind of what's working. So Leo, do you wanna start?
Sure. Yeah. I mean, there's a ton of topics we can touch on. One that came to mind I was thinking about today when we were talking about AI was just, I mean, as many people may be aware, and if you're not, it's certainly big in the copyright world is um, the overlap between AI and copyright law. And it comes up in a lot of ways with respect to your copyrighted works. A lot more people are using AI today to create copyrighted works. well, to create creative works, the question of whether it's copyrighted is a legal question, because essentially, and this has long been the Copyright Office position, but you need to be a human to author something to be considered a quote unquote author for purposes of having a work that's protectable under the Copyright Act. So that's been the subject of litigation, actually, in a number of ways. I'll just kind of break down the most high profile case, which is a programmer named Stephen Toller, who deliberately created a AI work through his own AI program that he basically trained and programmed and prompted to create some artwork. And so he tried to register the work as a work for hire under the theory that basically the computer is it's a work. The same theory for why somebody an employee who creates something in the scope of their employment might have created something for the company. So the Register of Copyrights refused that registration on the basis that there wasn't any clear human component to the actual artwork, and that's actually been litigated. That's been in the courts. It's currently on appeal, but the federal court in DC basically said, this is the rule, that there has to be human involved. It's the most basic element of copyright is human authorship and human creativity, and essentially the way that comes up for artists today and creators is that if you are using AI, you have to disclaim it with the Copyright Office. But that doesn't mean you can't get copyright. There needs to be some type of human element, whether it's the way you select and arrange materials, whether it's you might have a graphic novel. A great example was the Copyright Office allowed a graphic novel to be registered, but the photo, the artwork, was disclaimed. But the way that it was arranged and then the narrative and everything else, that was all part of the human element. So that's a great example of where we're seeing things like, that are some kind of fusion of both. And then the other big, yep.
I was going to ask you before you move on, can you give, I know you've been really involved in this and staying abreast of the developments of AI and copyright. If you could give, like a 30-second takeaway or overview for what you think these cases mean, or even some sort of, I would say, like summary of protectability of AI works.
Right.
You think you could try to do that?
Yeah, absolutely. So, I mean, the basic high level is that if you're using AI as a tool, that you need to disclaim it when you register the work, and that you're less likely to be able to get a registration if you're trying to claim protection over something that was essentially just prompted to an AI learning tool and something that AI spit out. But you are likely to get protection if you've done something else to that work, whether it's a compilation of different things AI put out or whatever the case might be. So yeah, there's that, and this is a subject for a totally other talk, but just a mass infringement going on with respect to AI tools that are being used they're using copyrighted works to train on. There's dozens of lawsuits right now. That's the subject of a whole other conversation that we can talk about in a future live stream.
I wonder if Nicole, do you have any comments about how AI plays a role in your negotiations? Because it's definitely going to be a thing. It is already a thing with, hiring celebrities and the ability for the people hiring them to use their name, likeness, and image in connection with an AI. So what are you seeing in that realm?
In those types of agreements, particularly when there's talent who has name, image, likeness, voice rights associated, now you're seeing the grant of the license either expressly include diffusions of the name, image, likeness vis-a-vis AI or not. Not typically because talent has already contracted with an AI provider and kind of exploiting that on their own. So that's kind of coming up on an individual talent level, with, and not everybody is keen on exploiting their AI rights for a variety of reasons, but it is something that we're seeing, particularly as it relates to exclusivity.
It's probably something, do you think it's better to address it, even if they don't want to have their AI rights? Do you think it's better that it's tackled during the negotiations as opposed to leaving it silent and dealing with issues later?
I would address it in the first instance, or even if you want to reserve your rights to make a decision on it later, I wouldn't leave the topic entirely silent, because I think that all types of rights associated have been exploited very easily and very quickly, and the law just isn't really keeping up with it. So I would prefer not to keep it silent. My preference would be to just reserve rights and figure out how you want to capitalize on it later on, if at all.
Thank you. Angela, I know we've been talking about patents in AI. Do you have any comments?
Yes. So similar to Leo, you can only get a patent for an invention that is made by a human being, not something made by a machine or through AI. Although it's still a hot topic to figure out, okay, well, if it's made with a machine, but there's the human intervention part, and how much does a human do, or how much does a human actually influence the results, if it is patentable, and kind of where that line is. So that part is still unclear, which is, I think, a little similar. It's similar to the copyright side of things for AI. In addition, patents in general have had what we call the 101 types of rejections and concerns with just computers in general. When you have a patent and you apply for a patent application, there are many factors that go into it, but if it is actually patentable is an issue that is what we call what is in section 101 of the patent code in the US. And those things are, okay, if we put code in the machine, if it's just the code doing something, what is actually patentable or not. Therefore, I think the patent office may have had a little more experience in this area prior to AI really taking off, but I think it still presents new concerns, and it's going to be interesting to find out kind of where everything goes in a couple years after more cases and more decisions are made from the standpoint of what actually gets granted and what goes through the court system.
Yeah, I know Nicole has a hard stop. Nicole, is there any last things that you want to say? And I can continue on for a little bit with Leo and Angela, and then we'll wrap up.
I think it's just something that I always counsel my clients to be aware of, is that this is kind of a new grant of rights that we didn't see previously. And if you have an intention to exploit it, really kind of figure that out early on. But it's something that we're talking about and learning from, and it's a really intriguing area of the law, as we all know.
Thanks, Nicole.
Bye, guys. Thank you.
Bye. I always say that just because it's a new medium and it's a new technology doesn't mean necessarily that this is presenting novel legal issues. We still have, or I would say rather, just because there's a new medium doesn't mean that there are legal issues that we can't solve with the existing tools that we have. So Leo, for example, when you were talking about the case of having a computer or an AI bot create what someone's trying to argue as a work made for hire, I'm of the side of, the PTO's position that there is no, this is a strict interpretation under traditional copyright law. If there is no human authorship, then even if it was an AI robot that was the employee or the independent contractor that had the work assigned, there shouldn't be copyright. So what are your opinions about the quote unquote novelty of AI in our world today? Do you think that these are really novel, challenging, hard issues, or do you think that we're just going to take the existing law and figure these things out eventually?
I mean, for copyright, for instance, some of these facts are new, certainly, but you're right. The issues themselves aren't really novel, and we have laws in place, particularly with respect to the infringement issues that are coming up. We've had traditional rules of direct and secondary liability for a long time now, and as we're seeing with all these cases, the rights holders are applying those rules, and they're seeking to hold these companies liable under those traditional legal principles. The big one I'd say that's going to be raised by a lot of the AI companies is fair use with respect to, they're taking all of these works, and their position is that they're transformative because they're not being used for their original purpose, but they're being used as a training set to train generative AI. In some ways, that's novel in the sense that there hasn't been any specific case where that's been argued because there hasn't been specifically generative AI, but there's been lots of mass infringement cases, like, the Second Circuit, for instance, just recently affirmed the lower court's decision that Internet Archive's mass digitization of library books during the pandemic was not a fair use. And that was under pretty basic principles that we can go back to, that we can trace back to in the Second Circuit and before the Supreme Court, and they're being applied. How they're being applied, and depending on how you feel about those issues, either correctly or incorrectly. But the courts seem to understand the issues, and I think that one of the main things in these kinds of situations is it's really incumbent on the lawyers who are litigating to make the judges smart on the technology and educate them as to why this technology, even if it's a new technology, falls under the same legal principles.
Angela, what are your thoughts?
My thoughts are that I think that the PTO has been on top of this for the patent side of it. And this year they just recently issued some new guidelines, and they're referring back to a two-step test that they use to determine the eligibility using computers. So that is all coming into play with AI-related inventions. And it seems like the really what they're looking at is AI inventions could be patent eligible subject matter, which means they could pass the first test when they're being examined by the patent office. But they're going to be looking at actually if there are technical improvements involved in inventions, if there's hardware implemented, and really specific details about if an AI model is used, what is actually done to the model to obtain the patent, as opposed to just say, was something used, did you use AI as part of your invention or not? And so I think that it's open that you can maybe get a patent using AI as part of creating your invention, but they really are using court decisions and tests that they have been using now for some time as technology has evolved. And as technology has evolved, the patent space seems to be evolving with that. And we'll kind of see how, if these guidance actually help or if it causes more disputes in the future since they are new, but I think that that's a good sign that they are trying to adjust and stay ahead of things. And like you said, Francesca, use the current standards that they are using and really applying that to just the new way that people are working using AI.
Yeah, I think the main takeaways, like from what everyone is saying, is that yes, this is a new medium, it's a new world, and it's important to stay abreast of it and not to write off AI or write off any of these technologies, but to really think, how can I take the existing laws and what we know about the law and apply them in creative, novel ways, in creative ways to advocate for our clients. And even though it may not necessarily be wildly, new legal issues, I think the landscape itself is enough to make people a little bit worried. And so I think having, like all of you on this live, really using your expertise and advocating for clients and for brands and artists on how best to protect themselves using what we know today is going to make a big difference. And I encourage everyone to not, you can't, I feel like everyone kind of knows at this point, this isn't going anywhere. Like this is going to be, AI is going to be a part of our new normal. So it's how do we get ahead of it and advocate for clients.
Yeah.
Oh, yeah. Anything else? You guys want to wrap up with anything on what you took away?
Closing words.
Yeah. Okay, great. This was awesome. Thank you all for joining. This was the ESCA Legal Lounge. ESCA Legal Lounge is here every Monday at 1 o'clock Eastern Standard Time. It's just a fun, informal time for us to chat as if we're drinking coffee, hanging out in our office, nerding out about trending topics like AI. Feel free to join us, share our links. If you guys have any questions, we're happy to answer them on next Monday. You can drop a comment below, and we look forward to seeing you all next week. Bye.